Hello, my name is Michael Tesoro, and I prepared this video entitled The Van Onselen Gamble. I'll be looking at the case of Network 10 Proprietary Limited and Van Onselen, which is a recent New South Wales Supreme Court handed down by Justice Hammerschlag, Chief Justice in the Equity Division. It's quite an interesting case about disparagement clauses. Now, my background, I'm a competition and consumer lawyer. I've been running my own practice to Sarah Legal Consulting for the last 15 years, and I help companies, individuals with competition and consumer law matters. Also do a bit of expert consultancy work for some legal publishers on competition and consumer law, including CCH, Walters, Kluwer, LexisNexis. Prior to that, I worked at the ACCC for 15 years in a variety of roles, including as Director of Enforcement. Now, the outline of the presentation, I'll be looking at Hammerschlag's judgment, and I'll start with the background, the issues identified in the case or the contentions, the decision of Justice Hammerschlag, which is a very good decision, the remedies that he ordered, and finish with some commentary. Now, the background to the case, the plaintiff was Channel 10, which has been purchased some time ago by the Paramount company in the US, and the defendant is Dr. Peter Van Onselen, who's a very well-known academic. He used to be on TV on a variety of shows. He's also a journalist, an author, and a commentator. And he's written a number of books. I guess I've listed a few there. Victory, a compelling read about Labor's return to power. How good is Scott Morrison? I guess there's a question mark at the end of that. So it's a curious title. Battleground, and the final one listed there is the Turnbull Gamble, which is the point of the talk, or the reason for the title of the talk, Turnbull Gamble. And I guess this is a talk about Van Onselen's gamble in making comment about Channel 10. So the background is that on the 3rd of March 2023, Channel 10 and Van Onselen decided to part company as employee-employer, and there was a deed of release signed, and Clause 7 is the key clause for the purpose of this case, and it was a mutual non-disparagement clause. So Channel 10 couldn't disparage Van Onselen, and Van Onselen couldn't disparage Channel 10. But then on the 29th of May 2023, so not a long time after he left the employ of Channel 10, he wrote an article for the Australian Business Review section, which spoke quite extensively about Channel 10 and its parent company, Paramount. Now, the background further is that in early 2023, 10 actually asked Van Onselen to relocate to Canberra, and he didn't want to move down there. So they decided to part company, and Channel 10 made his position redundant. And in February, they sent him a redundancy calculations, a draft deed of release, and a media release suggesting that Van Onselen had resigned rather than effectively being terminated through a redundancy. And there was redundancy payments, and there was quite a large amount of money paid to Peter Van Onselen, $165,000, $58,000 of which was payment in lieu, a redundancy payment of $35,000 plus an ex gratia payment of $71,000. I think it's fair to say that the $71,000 was most likely a payment for agreeing to the non-disparagement terms, or non-disparagement term of the deed of release. Now, here's the article in question, and as you can see, even the title sounds quite disparaging. Paramount woes raise questions about the long-term viability of Network 10. So he's raising questions whether Channel 10 is going to be able to keep in business. As you can see, he says there in the first paragraph that he assumed the future of Channel 10 was bright when he started working for them, but he started becoming skeptical about that, and he decided to walk away from the business. So the inference there is that he thought it was a sinking ship, and he decided to abandon ship. But the reality was that he didn't want to move to Canberra, and his job was made redundant. So suggesting he walked away is probably not entirely accurate. Then he talks about Paramount and says some very negative things about that organisation. He says there's reason to doubt Paramount's long-term viability. Their share price has plummeted, which is quite emotive language. It's down 80%. He's also talking about their strategy of the business, trying to get into streaming and make that a big part of the business, but that's actually the place where the business is losing a lot of money. So as you can see there, the subscription growth has not been strong enough there to make streaming profitable. He goes on to talk about the competitors to Paramount are doing a much better job, Netflix, Disney and Warner, and they're actually building up their streaming businesses significantly. Then he mentions Warren Buffett, who's actually the largest shareholder in Paramount. He owns 15% of the business. And he starts asking, what's Warren Buffett going to do? Is he going to stay in this loss-making business? He has a tendency of bailing when he thinks companies aren't performing well. But he notes there in the second paragraph that if Buffett were to exit Paramount, it cause a panic and share price would definitely decline very quickly. A lot of people follow Warren Buffett in investing in different companies. And then he says, irrespective of what Buffett does, analysts have by and large put a sell order on Paramount shares, seeing far more downside risks than upside opportunities with the stock. So he's obviously a very negative assessment of Paramount's share value. So then he talks about what it means for Channel 10, and he describes the company as limping along, saying that little attention is paid to it by its ultimate holding company, Paramount. And then for good measure, he adds in that the domestic competitors to Channel 10 aren't really paying much attention to it either. So fairly disparaging comment. Then he talks about the ratings slide, and he said the network's ratings have slowly ebbed lower and lower. And then he makes the comment that it has a meager 6%, a new low that one rival news executive, not the most reliable source probably, told Van Onselen that he'd never seen such low ratings in 30 years in the business. And then he makes observation that it can't be put down to the talent. They've got Sandra Sully, who's an excellent host. So if it's not the talent's fault, the newsreader's fault and the other staff, it must be the fault of the brand and management. And then he talks back about Paramount, and he talks about the fact that you'd be very brave to bank on the upbeat predictions of Paramount executives, given their predictions in the past have been wrong. And he also adds in that if they've been able to minimise the various failures in the past, then there wouldn't be these current problems. So as you see there, if they had the failures, could have been minimised and not spooked the market, resulting in a collapse, which is again a very, emotive term, of the share price. Whatever happens, one thing is certain, Warren is watching. So I think he's suggesting that maybe Warren Buffett's going to pull his shareholding, which obviously may create quite a bit of concern in the share market. Other people might want to preempt that possibility. So the non-disparagement clause was in clause 7.1 of the deed of release. And as you can see there, the first one is to prevent Van Onselen disparaging Channel 10, but also Paramount. And it's very broad. It says any statement or publication or authorise any other person to disparage the company or the releasees, and which may bring the company into disrepute or ridicule or otherwise adversely affect their respective reputation. So it's a very broad clause. 7.2 is a mutual non-disparagement clause, so Channel 10 can't disparage Van Onselen. Now, a lot of the case turned on this disputed conversation between Van Onselen and Mr. McDonald, who was a vice president at Paramount in human resource management. And I'll just read it out, not all of it, but the key points there. What Van Onselen claimed that he had a conversation with McDonald, and he said words to the effect, I assume the deed doesn't shut down my right to comment forever about the network. And then there's this sort of very strange bit of evidence in his affidavit. I mean, I'm not suggesting this, obviously, and it's deliberately extreme, but if the CEO effed a goat and everyone was piling on 10 for not sacking them, surely I can pile it on 2. So, a very extreme example. Something I guess you'd probably say is quite memorable. If you have a conversation with somebody and they said that, you'd definitely remember it. And so McDonald, who somewhat surprisingly said, of course, mate, that sounds fair. And then Van Onselen goes on and says, this deed is all about everyone just putting down their guns and walking away, so that with the distance of time, you're not silenced forever, meaning himself he's not silenced forever. I mean, I'm still going to be a commentator and teach media. So effectively saying here that he spoke to McDonald and said, there's going to be a carve out, even though, you can't be serious about wanting me to stop commentating about Channel 10 and Paramount entirely. Surely it's got to be narrower than that. I've still got to be allowed some free rein to comment on the business. And so that's his version of events. Now, McDonald's version of events is just totally different. he says, Van Onselen in McDonald's version says, I see the deed as a disparagement clause. After the deed is signed, I would take it that the network will not be saying negative things in relation to myself about Tegan George, which is a person who'd taken some legal action against Van Onselen, or how I have come to leave the network. So there the focus is very much on Van Onselen's ensuring that Channel 10 don't disparage him, not so much that he has some sort of residual right to disparage Channel 10. And as McDonald said in his statement, the network has no intention of making negative comments about you, but how the deed works to deal with that issue is a matter for the lawyers. So the lawyers have to sort that out. So they're very different versions of event, and Hammerschlag obviously had to decide which of those two versions of event was more credible. So the contentions raised by Channel 10 were as follows: that 10 is a weak, commercially unviable and worthless company. Sydney news rating performance is embarrassingly poor. 10's management is directionless, lacks competence, is to blame for the poor ratings. 10's US management lacks skill, competence and foresight, so Paramount, and Paramount is commercially unviable. So they're the disparaging comments which Channel 10 alleged Van Onselen made in his article, and there's no suggestion that these aren't necessarily true. Like, Channel 10's not saying that these are false claims, they're just disparaging, and that's the key of disparagement. It's not preventing somebody from saying something untrue, it's preventing from somebody from saying anything which lowers the reputation of the person or the entity in the view of the public, in this case probably the investing public. So some of these things are clearly correct, like the Sydney news rating performance is embarrassingly poor, and some of these other issues are true. So it's not a question of the truth of the statements, it's whether they have the capacity to lower the reputation of Channel 10 and Paramount in the minds of people in the market. Now, Onselen had a lot of claims, and I've got to say I think a lot of them weren't very meritorious, but I'll go through them all. Firstly, he claimed that the article did not disparage 10, which seems a bit of an ask, really. The clause is not to be construed as capturing statements made by him in good faith, so suggesting there's some sort of good faith carve-out from the disparagement clause. The true purpose of the deed was not to stop negative comments by Peter Van Onselen about... Sorry, the true purpose of the deed was to stop Van Onselen making comments about his employment, commentary about 10 as an employer, or the circumstances in which the employment was terminated. So he's saying that the purpose of the non-disparagement clause was much narrower, confined to those three areas, and also the Tegan George matter. The article merely restates information that was already publicly available, and 10 reputation has already been tarnished so much that really he can't tarnish it anymore. And there were a few further claims. There was a claim that the clause was actually in breach of the relevant legislation in New South Wales, the Restraint of Trade Act, as being an unreasonable restraint of trade. Furthermore, he argued that relief should not be granted because Channel 10 came to the court with unclean hands, and that's on the basis that he claimed that representations had been made to him by McDonald that there'd be this carve-out, and contrary to that understanding, they've actually taken to court. So he's alleged that's an unclean hands defence arises from that. And then two submissions on the relief sought. And interestingly, Channel 10 only sought a declaration and injunction, didn't seek any damages. And so the first argument is that the injunction should not be granted because it's not certain, it's broad, and it would be oppressive. And also that on discretionary grounds, the injunction should not be granted because Van Onselen's not going to do it again. There's no prospect or no realistic prospect that he's going to disparage Channel 10 or Paramount again. Now, the first issue that Hammerschlag had to look at is this different versions of events. And he notes that basically Van Onselen in his statements making a big deal about how he wanted this carve-out, but the carve-out that he discussed with McDonald is not reflected in the written deed at all. So he says it's a significant and plain departure from the operation of the terms of the provision to which Van Onselen later put his signature. So why would he sign a deed which doesn't embody the carve-out which he said to McDonald is so important? That doesn't seem to be a logical conclusion. And then he says further, Hammerschlag, that it seems that Van Onselen took no steps to ensure that the written agreement reflected what was this very important issue to him, that he be given free rein to continue commenting on Channel 10 and Paramount as a commentator. And he gave evidence that if McDonald had said to him, no, there's no carve-out, then he would have insisted on an express carve-out. But it doesn't seem to make sense that if he'd been so adamant about the need for a carve-out, surely he would have told his lawyers to insert a clause or to change the terms of the disparagement clause to make this carve-out clear. So ultimately, the judge concluded that his version of events wasn't really credible, that it had to be rejected in favour of McDonald's version of events. Also at the end there, he said, well, if it's so important, surely he would have communicated the substance of the conversation to his lawyer and told him McDonald's agreed to this carve out, and then the lawyer would have made sure that that was embodied in the deed. So none of the written evidence supported or corroborated the claims that Van Onselen had made in his statement and in the witness box as well. Now, as you can see there, the non-disparagement clause created no exception for fair comment. So one of the arguments that was put forward by Van Onselen was that he be allowed to make fair comment on Channel 10 and Paramount, but that's a sort of a strange thing, because disparagement isn't about whether things are true or false. It's just whether the reputation of an organisation is damaged by comments that are stated about it, regardless of their truth. And it's an interesting observation that the judge makes. He says this is not a defamation case, it's a breach of contract case. So there is no defence for fair comment. So you're importing concepts of defamation into a case that's about breach of contract. And then he says something quite interesting. He says this is a case about the right to free speech, but only to the extent that by the deed, Dr. Van Onselen bargained that right away. So people do have a right to free speech. That's Hamish Lugg's view. But if you get paid a lot of money in a deed of release, and there's $70,000 paid to you pretty much for an agreement not to disparage your former employer, then you've actually bargained that right of free speech away. So you sort of you've bargained for that, and you're stuck by your bargain. So I think that's an important observation, the fact that he was paid quite a lot of money for not disparaging Channel 10 and Paramount going forward. Now, there was an allegation that the terms weren't disparaging of Channel 10 and Paramount, and the judge dismissed that pretty quickly. Said the criticisms in the article are hardly expressed in neutral terms. He concludes that they are undoubtedly disparaging, and he goes further and says that if he had needed to decide the point, he would have concluded that the disparagement was actually intentional, that Van Onselen had gone out of his way to disparage Channel 10 and Paramount. And then he notes that clearly the tenor of this particular article was to cast doubt on 10's long-term viability and to convey the impression that Paramount was potentially going to cut its losses and dump the business. So it's a very serious comment to make, particularly by an influential commentator. This has got the potential to really spook the market and result in some people probably unloading their shares in the group. So there was also quite a close analysis of the article and some of the terminology used, and this is the basis on which Hamish Lugg concluded that it actually was likely to be intentional. So as you can say, the comment in the article that he was at Channel 10, he thought the future looked bright, but then he walked away, and that's suggesting that he, as I said earlier, that he saw a sinking ship and wanted to get away from it quite quickly. And as the judge says at that first paragraph, walked away is used in the article is not a neutral analytical term. It's emotive, it's value laden. It's probably also not accurate too, because he didn't really walk away. He didn't want to move to Canberra, and as a result his position was made redundant. And then the other words he used to describe Paramount's share prices plummeting, which is again a very emotive term, and he notes that he could have said just decreasing, and he describes 10 as limping along. So like somebody who's very unwell, obviously, and little attention paid to it by Paramount. So a lot of these comments are very disparaging and likely to be intentionally so. And as I said earlier, and obviously wasn't lost on Hamish Lugg, this type of disparagement can self-evidently undermine the confidence of investors or potential investors in 10. This is not a trivial or insignificant matter. So this is very serious disparagement of both Channel 10 and also Paramount. And I think also creating this fear that maybe Warren Buffett was going to pull the pin as well, enhance that level of fear. So there was also this submission that somehow if you disparage somebody with publicly documented information, that's okay. And again, that's a misunderstanding of the way disparagement clauses work. It doesn't matter if the information is publicly available. If he'd used confidential information to disparage Channel 10, I think there would have been a further action for breach of confidence. But here, you can disparage somebody using any type of information, publicly available or not. But the other point that Hammerschlag makes is that this isn't really just a mere recitation of publicly available information. Rather, Van Onselen has provided analysis, comments, views, inferences, conclusions, brought together in a pejorative whole. So he's added a lot of value to this information with various insights and takes and I guess speculation as to how all this information is going to come together and affect the financial fortunes of Channel 10 and Paramount. So there was a case, the question of whether this was a restraint of trade, and it was interesting. Hammerschlag concluded that a disparagement clause could, in certain circumstances, amount to restraint of trade and thus be in breach of the relevant legislation. But this particular deed of release wasn't of that nature. He said it did not muzzle Van Onselen entirely and also did not restrain him in his trade or calling in any meaningful way. So it wasn't really restricting the way he could talk about these companies in entirely. And I guess the other thing he noted that I guess even if, say, it had been a restraint of some sort, he thought the connection between the restraint and any supposed economic prejudice was too remote to result in being fairly viewed a restraint of trade. So couldn't see a lot of damage being done to Van Onselen's job and his remuneration from this restraint. And then I guess the fallback position is that even if it was considered a restraint of trade, he didn't believe that it would be struck down because it was within Channel 10's legitimate interests to have the non-disparagement clause in order to protect its goodwill. So it would have been found to be a reasonable restraint of trade. And he also made the conclusion that it wasn't against the public interest. So obviously when you're looking at restraint of trade, there's a public interest element of the assessment required. So he concluded, and this is going to the relief, that he concluded that it was a very serious breach of the disparagement clause. You can see there that the construction of the deed put on it by Van Onselen was not sustainable, that the breach was not trivial, and accordingly, due to the fact it was not a trivial breach, it was appropriate for the court to order a declaration of breach. So the court ordered that Van Onselen had been found to have breached the disparagement clause in the deed. However, turn to the interlocutory or the injunctions sought by Channel 10. As I said earlier, they only sought injunctions and declarations, didn't seek any damages. And here Hammerschlag decided that not to grant the injunction because he didn't believe there was any realistic risk or possibility that Van Onselen would breach the disparagement clause again in the light of my findings. So I think the suggestion there is you'd be pretty crazy to go and disparage Channel 10 and Paramount again, given what the judges found about the operation of the clause 7.1 of the deed. And Hammerschlag characterises Van Onselen's conduct as a one-off mistake. And there's an interesting comment here. I think there's a bit of a warning to Van Onselen. It will also be obvious that if there were to be any further non-inadvertent breach, the assertion of a lack of risk could not be legitimately put in any further proceedings seeking injunctive relief. So if he does it again and then comes forward and says, no injunction should be ordered because I'm not going to do it again, obviously wouldn't hold any water. So that seems like an obvious conclusion. But I think it's also a bit of a warning for Van Onselen not to gamble on this disparagement clause again. So I think it's a very interesting case. There's not a whole lot of cases that I've seen that look at the way disparagement clauses work and actually find the disparagement clause to be effective. And I guess as a practitioner, you've got to be very careful when you're looking at these clauses. Firstly, to make sure if you're representing an employee that it's a mutual non-disparagement clause, but also that the scope of it is appropriate, that it's relatively narrow in the way it stops disparagement, and also that there won't be any implications arising from the use of the clause that might interfere with your client's ability to earn their living in the future or do various things, depending on what their occupation is. And I guess the other thing that's important, as you can see, this turned on various conversations and the fact they weren't reflected in the deed. And I think there's any conversations about the scope of a disparagement, non-disparagement clause, that practitioners make sure that those discussions are fully reflected in the actual written clause that's in the deed, and never sign a deed that doesn't fully reflect the agreements reached in discussions about the scope of the deed. So that was, I guess, maybe the fault in this particular case of Van Onselen. Did have a conversation and did specify some requirements, and they weren't translated into written form. Alternatively, maybe the conversation didn't happen. I think that's basically what Hammerschlag decided, that it was McDonald's conversation that was the credible one. I think the fact that Van Onselen got a pretty big payout and it could only be attributed to the non-disparagement clause was very relevant. The judge mentioned that there's a right to free speech, but you can bargain that away in a termination agreement, and if you do bargain it away, you're bound by your bargain. I think Van Onselen, through legal team, through too many issues at the court, you really got to sort of focus on your best arguments. There were some arguments there that seemed to be more appropriate to a defamation hearing, which wasn't appropriate. I think saying the comments weren't disparaging was a bit of a weak submission, because they clearly were very disparaging. So I think, they probably raised, I think, about 9 submissions, and I think probably you could have gone with half of that. Leave out the ones that the judge is going to dismiss pretty quickly, because they really don't have any merit, and focus on your best ones. Clearly the best ones were some of the submissions put on the relief that should be granted. They were largely successful. So I'd conclude that Van Onselen's gamble did not pay off, that he thought he could write about Channel 10 and Paramount without invoking the disparagement clause and taking to court. So that gamble failed, and I think he might have thought that they were going to come after him, but they did, and they were very successful. The fact that they didn't seek damages against him may suggest that the outcome could have been worse. Like maybe Channel 10 didn't seek damages because they couldn't prove damages, or they didn't want to go down that path. But he took a big chance in that regard, because if he'd written this article and there'd been sort of an immediate impact in the market, particularly the reference to Warren Buffett and the entities that suffered a significant decline in shares, maybe they would have gone after him for damages, and I think they might have been successful had they done so. So even though Van Onselen's gamble did not pay off, I think maybe it could have been worse, given there was no claim for damages. And the final thing I'll say is Hammerschlag's judgment. It's a really exceptional judgment. You read so many judgments that are very long and quite hard to get through, a bit tedious. But Hammerschlag, very experienced judge, and he's obviously the Chief Justice in Equity. But it's a relatively short judgment, deals with a lot of issues, very economically, very decisively. So it's really, I think, a very good template for the way judgments should be written. Nice, short and sweet. And so I'd really commend that. Even if you don't practice in this area, I commend that judgment as something well worth reading. It's a very good read. So that's all I had. I think finally Van Onselen's gamble did not pay off, and he'll probably learn from the experience. I guess if you have any questions about this particular presentation, feel free to give me a call or send me an email. Bye-bye.